The title of today's topic is Reformation of Juvenile Homes. Let us have some introduction. Children constitute the most vulnerable section of society and are important national assets. Children are the future of our country, and it is the responsibility of everyone that they have a safe environment to live in. Socio-economic circumstances of a family often result in family stress, disintegration, and child destitution. A child is a bona fide citizen with full human rights as much as an adult citizen. It is the duty of the state to devise programs, frame policies, enact laws, and duly implement them to protect the rights and interests of the children. But what is worrying is that rate of crimes committed by juveniles has increased in the last few years. Crimes committed by juveniles have increased by 85% between 2001 and 2011. Youngsters are not just committing petty crimes, but heinous crimes like rape and murder. Juvenile delinquency. The term juvenile originates from a Latin word juvenis, which means young. A juvenile is a minor who has not completed 18 years of age. Delinquency is understood as an act, conduct, or interaction which is socially undesirable. In simple language, delinquency denotes deviation from normal behavior. Thus, juvenile delinquency refers to the socially undesirable acts of children. Juvenile delinquency also covers those conducts prohibited by criminal law. Juveniles are capable of committing the same crimes as adults. Because of the offender's status as minor, acts of children are separately treated than those of adult offenders. The justice system as available for adults is not considered suitable for being applied to a juvenile, and thus a separate juvenile justice system is introduced for treatment of juvenile delinquents. Nowadays, the term delinquent juvenile has been substituted by the words juvenile in conflict with law. Juvenile delinquency has been a global concern. The growing consciousness of the world community led to the adoption of various rules, standards, guidelines, and declarations for prevention of juvenile delinquency across the globe. Some of the important international instruments are the United Nations Standard Minimum Rules for Administration of Juvenile Justice 1995, the Vising Rules, the United Nations Rules for the Protection of Juveniles Deprived of Their Liberty 1990, the United Nations Guidelines for the Prevention of Juvenile Delinquency 1990. These sets of rules intended that social policies should be evolved and applied to prevent juvenile delinquency, to establish a juvenile justice system for juveniles in conflict with law, to safeguard children's rights, and to establish methods for social reintegration of young people who had suffered incarceration in prison or other corrective institutions. The Vising Rules provided that efforts should be made by member countries to establish within their own national jurisdiction a set of laws and rules especially applicable to juvenile offenders. Another milestone in the journey of juvenile justice system is the adoption of the Convention on the Rights of the Child by the United Nations on the 28th November 1989, which emphasizes conferment of rights on children and reintegration of juveniles and care and protection of vulnerable children with a view to furthering their right to survival, development, protection, and participation. Now we will discuss juvenile justice laws in India. The Constitution of India has in several provisions including clauses 3 of Article 15, clauses E and F of Article 39, Articles 45 and 47 impose on the state a primary responsibility of ensuring that all the needs of the children are met and their basic human rights are fully protected. The juvenile justice policy in India is structured around the constitutional mandate as well as several international instruments. The country had some laws dealing with juvenile delinquency such as the Children Act 1960, the Juvenile Justice Act 1986, etc., which were repealed by respective subsequent legislations. The existing law on juvenile justice system, namely the Juvenile Justice, Care and Protection of Children Act 2000, is now operative throughout the country with effect from December 30, 2000. This act has been further amended twice in the years 2006 and 2011. The present law is in tune with the provisions of the Constitution and the relevant international instruments relating to the juvenile justice adopted by the United Nations. The Act seeks to adopt a child-friendly approach in the adjudication and disposition of matters in the best interest of children and for their ultimate rehabilitation. The law provides a special framework for the protection, treatment, and rehabilitation of juveniles in conflict with law and children in need of care and protection. It excludes the jurisdiction of courts in the sense that juveniles accused of committing a crime are not to be produced before a court, rather before a juvenile justice board which shall consist of a metropolitan magistrate or a judicial magistrate of the first class and 2 social workers, at least one of whom should be a woman. It prohibits joint proceeding of juveniles with other adult offender, even though the alleged crime may have been committed by the juvenile and other adult accused persons in groups. When any juvenile is arrested, the officer in charge of the police station or the special juvenile police unit to which the juvenile is brought as soon as may be after the arrest has to inform the parent or guardian of the juvenile about his arrest and direct him to be present at the board before which the juvenile will appear, and he has also to inform the probation officer of such arrest to enable him to obtain information regarding the antecedents and family background of the juvenile. An arrested juvenile shall be released on bail as a general rule. Where the board rejects the bail application of the juvenile, keeping in view of the gravity of the offence and his antecedents, he should not be remanded to prison custody, but instead sent to observation home or any other safe place or institution. Where after holding an inquiry or hearing in the case of a juvenile in conflict with law, the board finds that the offence is not of a serious nature it may order discharge of the juvenile after admonition. The Juvenile Justice Board may order the release of juvenile in conflict with law on probation of good conduct and place him under the care of his parents, guardian, or any other person. Having regard to the circumstances of the case, the board may also direct the juvenile to enter into a bond with or without sureties. But the period of such order of release on probation shall not exceed 3 years. The maximum period of detention of a juvenile found guilty of commission of a crime in a juvenile home is 3 years, no matter how serious the crime is. Now let us discuss juvenile homes. The Juvenile Justice, Care and Protection of Children Act 2000 envisages establishment of juvenile homes for both types of children, namely juveniles in conflict with law and children in need of care and protection. There are two categories of homes for juvenile in conflict with law, namely observation homes and special homes. This lesson emphasizes on these two homes. Observation home is the home where a juvenile who is alleged to have come in conflict with law, that is to say, allegedly committed an offense, is kept pending inquiry against him by the board. Observation homes for temporary reception of juvenile may be established and maintained by the state government, either by itself or under an agreement with a voluntary organization in every district or group of districts, separately for boys and girls. Special home is the home for reception of juveniles who are found guilty on the conclusion of inquiry against them by the board and sent for institutional care. Special homes for reception and rehabilitation of juvenile may be established and maintained by the state government, either by itself or under an agreement with a voluntary organization in every district or group of districts, separately for boys and girls. The observation homes and special homes shall be child friendly, and it should not look like a jail or a lockup. The observation homes or special homes shall set up separate residential facilities for juvenile up to 12 years, 13 to 15 years and 16 years and above. The institutions shall have sufficient space for every juvenile and shall include a minimum of following facilities like dormitory, classroom, workshop, playground, etc. Every institution shall also have basic facilities including treated water for drinking, bathing, washing, sufficient number of toilets, facilities for medical and health care. Every institution shall provide education to all juveniles inside the institution or outside. It shall also provide gainful vocational training to juvenile. In addition, every institution shall have a daily routine for the juveniles developed in consultation with the children's committees, which shall be prominently displayed at various places within the institution. The daily routine shall provide for a regulated and disciplined life, personal hygiene and cleanliness, physical exercise, yoga, educational classes, vocational training, organized recreation and games, moral education, group activities, prayer and community singing, and special programs for Sundays and holidays. Now let us have some evaluation of juvenile homes. An evaluation of all types of juvenile institutions shows that lifestyle in these institutions is not at all satisfactory and inmates enjoy little freedom. The homes are mostly overcrowded, management is centralized, training programs are very traditional, individualized attention is not paid, life is by and large dull, their budgets are rather low, and the number of juvenile homes is very inadequate. Escapes from these homes have been a regular feature now for many years. There were reports of torture and sexual exploitation occurring in the homes. Younger boys in the homes virtually live under the dictatorship of senior boys. Sexual abuse of younger children is common in the homes and authorities turn blind eye to it. No special classes were being held as stipulated by law. Medical facilities are inadequate, care and counseling are lacking, facilities to inmates for communicating with family members, kin and friends are also inadequate. Even if it is assumed that some changes have been introduced in these juvenile homes in the last few years, it can be safely said that there is great need of restructuring or reforming these homes. While children in need of care and protection are continued to languish in poorly managed children's homes, juveniles in conflict with law are continued to be treated as criminals. Now let us come to conclusion. In spite of having such a comprehensive law in India, it is often felt that there is an inherent risk of violation of child's rights within the juvenile justice system. There is growing feeling that the police should be more serious in the case of children who need special care and protection. There is not much awareness about proper implementation of the legislation. Empirical researches in juvenile delinquency have suggested that the only alternative to suppress criminality among children and young persons is to impart them proper education and training in schools and homes. Studies conducted by the National Crime Record Bureau, Ministry of Home Affairs, Government of India revealed that poor education and poor economic setup are generally the main attributes of juvenile delinquents. The problem of juvenile delinquency is intimately related to other social problems, and therefore it can be effectively tackled by devising measures to secure community cooperation and public support through voluntary service organizations. It is desirable to establish at various levels People's Committee to tackle the problem of juvenile delinquency right from the time of apprehension of the juvenile to his final rehabilitation in the community. Thank you.